Greetings, members of the Vino Veritas Society. You know, we're always trying to be a little edgy here, so I'm going to go ahead and welcome you as the ladies and gentlemen of the Vino Veritas Society, which is kind of an edgy thing in an age of fluid genderism. I, of course, am Tom Cranwitter, your gracious host. This is an unusual podcast for us, for me. Usually, I have my partner Dave Rich as my co-pilot on these things. We've done, I think we're at 75 or 76 now, and we have been really consistent. We have not missed a week. We've done these together, no matter what has been going on. But this week I am flying solo. Dave is out of commission. He's got the bug. He's got the COVID, and I'll tell you, he's struggling. It's been a reminder to us, and I'll share it with you. I mean, this thing it's real and it's nasty. I'm hoping and praying Dave's going to be okay, but he's been struggling. Some of you, I know this about him. He had a number of other long-term sort of chronic health concerns and special medications, and so his doctor wasn't real eager for him to take the vaccine because they were worried about that the vaccine itself could cause certain problems. So he did not take the poke. I did take the poke several months ago, and so far as I know, I don't think I've had the bug. But Dave got it, and he's been wrestling with it. So I'm gonna actually devote a fair amount of time today to COVID and COVID-related things, especially unconstitutional exercises of power related to COVID. But before I dig into all of that, I thought it was worth commenting on a little bit. This whole pandemic, the whole problem of COVID has really highlighted the importance of trust between friends, trust between, colleagues, coworkers, friends, fellow citizens, and there's a special kind of trust with your physician. And this thing certainly has highlighted that, making sure that you find a physician that you really can trust. It's a funny thing. We modern Americans have grown up in an era where most of us we trust medicine, medical science, we trust medical physicians, practitioners of medicine, and that hasn't always been the case. I used to like to joke around when I would be in the presence of physicians. I would ask them something of a little trivia question, and that is, when did medical science start to heal or cure or help more people than it killed? And the answer, by the way, is about a century ago. In the early 20th century, the 1915s, 1920s, right in that area, is when medicine, which is an ancient practice, right? Medicine goes all the way back certainly to the ancient Greeks in the Western tradition, and even older in other traditions. So medicine has been around for a long time. And it's also true throughout most of the history of medicine, you did not want a physician coming around because medicine was in such a primitive state. There was so little that was known. It had incorporated so many mistakes and errors and myths and unproven assumptions that medicine typically was more lethal than helpful. And this goes all the way up, certainly, well, as late as the Civil War in the 1860s. If you had some terrible injury out there on the battlefield, and you would be in one of those medical tents, the truth is the last thing you wanted was for a physician to come get a hold of you, because very often those physicians it was just gruesome what would happen in these medical tents during the Civil War. They would take one saw and they would just go from patient to patient to patient, sawing off infected limbs or mutilated limbs, arms, legs, and they weren't cleaning anything in between. It was absolutely terrible, as you can imagine. And so certainly there have been huge advances in the actual science, the actual technology of medicine. And I would add something that is just as important as the actual science behind medicine itself, which is always evolving, always changing. Uh, Science is really is an ongoing experiment, proposing one hypothesis after another, all of which should be rigorously challenged. If there's a mistake, if there's something that's unproven, unfounded, we want to know that. And at the same time, one of the developments that really transformed medicine was the discovery and implementation of property rights and individual liberty. Now, some of you might be thinking, well, wait a minute, what do property rights and individual liberty have to do with medicine? Well, it has to do a lot with medicine, because what individual liberty and the right to one's own property, including one's own body, what that means is nobody, including a physician, nobody can come mess with your body, come muck around with your body without your permission, without your consent. So, think of all the arrangements around the practice of medicine. Physicians take their Hippocratic oath, of course, that they're only going to, heal and not cause harm to patients. We have a whole system of criminal law, tort law. If a physician does something purposefully or even out of negligence, does something that's harmful to you, we have a body of law to help protect us from injury in that way. And framing all that is the natural freedom to decide who do I trust as an individual. What physician, if any, do I trust? And I can go and talk to several and get to know them and figure out which one I think is, which ones are more competent, which ones are less competent, and I get to choose. It means there's competition, at least to the degree that there's any semblance of freedom left in the medical world. That idea of competition and people choosing the kind of physicians that they want to work with and take advice from it's a big part of it. And boy, that has never been more important, that notion of finding a physician that you can really trust, because not only is this COVID bug it's a nasty little virus. It's a virus. Keep in mind, not only is that whole family of coronaviruses troublesome, it's looking increasingly like this is a coronavirus that was engineered, that was actually made to be more dangerous than it already is out in nature. And so it's not something to take lightly. It's real. It's serious. It causes lots of problems for lots of people. It's causing problems for our own David Rich right now, and we're going to send him the best. And I promise you, as soon as he gets back in the saddle, these podcasts are going to become better than they are just suffering with yours truly. With that in mind, I'm going to shift gears here just a little bit and talk about another COVID-related subject. The Biden administration instructed the Department of Labor, which then instructed OSHA, the Occupational Safety and Hazard Administration, to issue a regulation, enforce a rule upon employers with more than 100 employees by, I think the deadline they had, it was early January 4th, I believe. The rule was that all employers, private employers, I'm talking about private businesses, if they had 100 employees or more, those employees had to show proof that they had been vaccinated or take regular tests, I think once a week, something like that, or could not be employed, had to hit the road. And just a few days ago, a district court in the Fifth Circuit down in New Orleans issued a stay. A stay is just a legal word meaning a pause. You got to stop enforcing this. You may not implement this because the court thought there was a problem. And I just learned today that they do this sometimes when there are multiple lawsuits. So when Biden issued this executive order, this directive to the Department of Labor, which then ordered OSHA to go implement this new regulation. Many states and other organizations filed lawsuits against us that this is an illegal and unconstitutional action. And so what happens is when you have multiple states suing the federal government, the question is, where should this be heard? In what circuit court should take up this question? And they do a lottery. Literally, they arbitrarily pick one of the district courts, and they just selected the Sixth Circuit Court, which will hear this case about OSHA and these regulations about commanding private businesses to make sure that their employees, to force their employees to be vaccinated, or else they have to fire them. And what I wanted to do with this topic here is I wanted to dig a little bit into the legal and the constitutional framework, because it's a perfect example of how we Americans, and especially we constitutionalists, we who care about constitutional government, we really have let ourselves be put in a bad position, really a pickle, where there's just no easy way out. And I want to explore a little bit here. I'll preface it this way by saying, as many of you, many of our members of the Vino Veritas Society, of course, you're probably thinking, well, this regulation, this rule that's going to be implemented by OSHA, of course, that's unconstitutional. It's illegitimate. It is. Here's where it gets challenging. OSHA itself is unconstitutional. In fact, the Department of Labor, of which OSHA is part, is unconstitutional. And this is how we have come to be in a really difficult position. We've allowed these unconstitutional departments and regulatory agencies and other offices and bureaucracies, we've allowed them to stand. And then when they do something unconstitutional, we run around and say, well, that's constitutionally illegitimate. That needs to be struck down or stopped or repealed, whatever the action is in question. In a way, you could say, you could put it like this: either the Constitution matters or it doesn't. I mean, we could all agree to that, right? Either the Constitution matters, and if it matters, then it should matter for all subjects, for all government actions. Or if we want to say, well, the Constitution just doesn't matter, then who cares? Then there's really no ground to challenge anything that the government does. If this is the great danger of buying into the whole progressive notion of a living Constitution, that the Constitution is an evolving document whose words, even though the words on the paper don't actually change, the meaning changes. The meaning is, to use a term that's popular today, the meaning is fluid. It's always becoming something else. Well, that means then we, the citizens, we can't really know what the Constitution means. Whatever we thought it meant yesterday is not what it means today, and whatever it means today is not what the Constitution is going to mean tomorrow. Effectively, that's a way of saying there's no Constitution at all. And if we, the citizens, agree that the Constitution does not matter, then we're in a really bad position, a really weak position to challenge anything that the government does, whether it's this latest vaccine mandate or anything else. So we who care about freedom, we want to say, yeah, the Constitution matters. Absolutely. Damn right. The Constitution really does matter. But what happens then when our government creates unconstitutional agencies and we don't push back? We allow that thing to stand. And then that unconstitutional agency does something unconstitutional. It issues, or an unconstitutional regulation or enforces an unconstitutional rule. You see that the challenge there, we're not on very firm ground to stand up and say, well, we object to what this unconstitutional agency is doing, in this case, OSHA. We object to what it's doing because it violates the Constitution. Well, If it violates, where was our concern for the Constitution when it was created? I'll give you just an example here. I have printed out a passage. As I mentioned, OSHA, the occupation. I'm terrible with acronyms, so I always have to remind myself. It's the Occupational Safety and Hazard Administration. It is part of the Department of Labor. Now, the executive branch of the federal government now comprises 15 separate departments, ranging from the Department of Labor to the Department of Education. The most recent one, of course, is the Department of Homeland Security. There's the Department of Defense, which is one of the larger ones. And within those 15 department levels, that's a cabinet level, meaning each of those departments has a secretary that is a political appointee. The secretaries typically are nominated by a president, confirmed by the Senate. Now, none of that, by the way, is constitutional. This is woven into the laws that create these departments. In fact, the departments themselves, there is nothing in the Constitution that says you have to have a Department of Defense. It doesn't say that. It doesn't say that you have to have a Department of Education or a Department of Homeland Security. All these departments were created by acts of government. Now, the one that's of our interest today, the Department of Labor, which is home to OSHA, was created. This is going to surprise nobody. In fact, I'll do a quick little trivia question here. When do you think the Department of Labor was passed? And I'll give you a little hint. It was a really bad year for constitutional government. The answer is 1913. The Department of Labor was created. And it actually was not Woodrow Wilson. Even though Woodrow Wilson was sworn in as president, Taft, on the Republican, on his very last day in office, he's actually the one who signed the bill creating the Department of Labor. I mentioned 1913 was a really terrible year for constitutional government for a number of reasons. I'll just kind of summarize it. This in itself is an entire podcast we'll do sometime on the year 1913. Let's see what happened in the year 1913. Well, I already mentioned one thing. I mentioned two. Woodrow Wilson was inaugurated president. He had won the election in November of 1912, running against Teddy Roosevelt, the Republican progressive, and Wilson was the Democrat progressive. They were virtually all progressives in that contest. And so what 1913 and Woodrow Wilson represent, it's the first time in American history where someone openly, overtly critical of the founding of the Constitution was sworn in as President of the United States. In fact, in his first published book, Woodrow Wilson described the United States Constitution, your Constitution, my Constitution. He described it as political witchcraft, something evil from the past that we need to either get rid of or redefine or circumvent. He viewed the Constitution as a kind of obstacle, something we have to get over, get past, get beyond, which raises an interesting question. What did that oath of office, right? As president, he took an oath to preserve, protect, and defend the Constitution of the United States. What does that mean when he's written a book explaining he thinks the Constitution is this evil thing? Anyway, that happens in 1913. I mentioned the Department of Labor was created in 1913. Americans, in all their wisdom, passed not one but two amendments, both of which have been disastrous. The 16th Amendment to the United States Constitution, which granted Congress the power to tax your income personally, directly. The federal government never had any constitutional power to lay a direct tax on your head, on your person, on your personal income before the 16th Amendment. And then the 17th Amendment really changed the whole nature of constitutional government, because it changed the manner in which senators are elected, United States senators. Prior to the 17th Amendment, senators, U.S. senators, were selected by state legislators. And if you know anything about state legislators, some of you who are listening to this podcast, some of you have spent some time around state legislators. A few of you are state legislators. And so you know better than anyone, state legislators tend to be really jealous of their power. They don't want to give their power up. They don't want the federal government coming in and doing things that the state is supposed to do. And so the framers of the Constitution wisely gave that power to state legislators because they thought no senator is going to step on the toes of state governments. If a measure, if a bill, if a policy was circulating around Congress that would authorize the federal government to do things that really should be reserved to the states, the idea of the founders was that bill, that policy will never pass the Senate because those senators are accountable to state legislators who are really jealous of their power. The 17th Amendment changes that, and it replaces, in place of state legislators, it adopts the popular election. The people of a state, the voters of a state, elect U.S. senators now. And so candidates for the U.S. Senate can run for the Senate and offer some pork, some grist, some subsidies, right? Some kind of bribe for votes and get elected to the United States Senate. And most ordinary citizens are not thinking about that constitutional division between the federal government and federal power versus all the power that should be reserved to state and local governments. Also in 1913, Congress creates the Federal Reserve through the Federal Reserve Act and creates this financial economic institution with tremendous power and influence at a time when virtually no one really understood monetary theory. There weren't many people who had studied the science of what happens when you adjust interest rates and you either increase or decrease the money supply and these kinds of things. It was an unknown science, and yet the Federal Reserve created this institution that would have enormous influence. In fact, a generation later, I'm persuaded that the Federal Reserve was one of the reasons why the Great Depression was much deeper and much longer than it needed to be. Also in 1913, a historian named Charles Beard published just a dreadful, terrible book. I have it somewhere on my bookshelves over here, titled An Economic Interpretation of the Constitution. And his whole thesis in An Economic Interpretation of the Constitution was that the arguments in this book, this is my old copy of the Federalist Papers, that these arguments here, they were scandalous. That's really his accusation against the Federalist Papers, that the Constitution was written by a few rich elites, and yet they needed the support. They needed the ratifying voting support of the poor many. And so this is Charles Beard's argument in his 1913 book, An Economic Interpretation of the Constitution. These Federalist Papers, according to Beard, they were written as a way to fool the many poor in America into thinking that the Constitution was somehow in their interests, that the Constitution somehow advanced or promoted a common good, the public good, that was good for poor people too. And Beard was persuaded that was all false. That the Federalist Papers are nothing but a bunch of lies. The Constitution, he argues, the Constitution was written by rich people, for rich people, and therefore it must be bad for poor people. And his book became wildly popular for 2 generations. His book was taught in colleges and universities and high schools around the country. In fact, there was a period of time there in the 1920s and 30s where the Federalist Papers, you couldn't, it was hard to get them because no publishers were publishing the Federalist Papers. And the reason they weren't being published is because no professors, no teachers were teaching the Federalist Papers. And the reason they weren't teaching the Federalist Papers is because they were teaching Charles Beard's book, An Economic Interpretation of the Constitution. All that happened in 1913, including Congress passing the law that creates the Department of Labor, which really represents kind of the one of the great victories of the progressive movement. And I want to read to you here. This is from the actual what is called the organic law, because it's the legislation that actually created the Department of Labor. Here's its mission, its main purpose, according to federal statutory law. The purpose of the Department of Labor is, and I'm quoting here, to foster, promote, and develop the welfare of working people, to improve their working conditions, and to advance their opportunities for profitable employment. Think about that. To promote the welfare of working people, right here you can see how this thing is it's tribal. It's dividing people into groups, right? If you're a working person, if you're employed, then you have an entire federal agency that's there to help you. If you're not working, well, then the federal government doesn't have anything to offer you. Promote the welfare of working people, improve their working condition. This is the job of the federal government now, and to advance their opportunities for profitable employment. So not just employment. The government's the Department of Labor is not only going to make sure you have a job or job opportunities, but profitable. You should be able to make money, maybe as much as you want. And that's not going to be something you negotiate with a business owner. That's going to be something that's going to be set by the Department of Labor. Here's my point in reading this. If you read through the United States Constitution in Article 1, Section 8, if you've never read that, I highly, strongly encourage you to do it. It's very short. There's a list of 17 powers that we, the people, grant to our Congress. Among them is no power at all, to create a Department of Labor that will promote the welfare of working people, improve their working conditions, and advance their opportunities for profitable employment. That is not a power granted to Congress. And yet Congress writes a bill, passes a bill, the president signs it, creating a Department of Labor for these purposes, which are nowhere mentioned in the United States Constitution. And that agency is now, that department, the Department of Labor is now over a century old, and it is constitutionally illegitimate. And this is my point about when we today, we Americans, we citizens, when we say, well, that department is doing, or one of the agencies like OSHA within the Department of Labor is doing something unconstitutional. The premise, there's an unspoken premise there. When we say OSHA or the Department of Labor is doing something unconstitutional, what the premise is that the Constitution should matter. That should be a big deal. If any part of the government is doing something unconstitutional, it should be stopped. It should be repealed. It should be abolished, right? This unconstitutional activity should not be allowed to stand, to continue. And yet we, the citizens, we have allowed our Congress to create unconstitutional departments and then unconstitutional agencies within those departments, and we haven't challenged them. And so we're not in a strong position when we go after particular actions, particular regulations. And that whole notion of regulations itself is highly, highly problematic. What does OSHA do? The Occupational Safety and Hazard Administration. What power do they have? What can they do? Well, what they can do is they can write and issue regulations and enforce them against your business, against your property. And if they think you are violating one of their regulations, they will arrange for an administrative hearing. The administrative hearing is going to be you in front of a bunch of bureaucrats from OSHA who are going to sit and decide whether or not you've actually violated OSHA regulations. And if they find that you have violated OSHA regulations, terrible things can happen. You can be fined. Your business might be shut down. You potentially could go to prison for these things. These regulations are treated as law. And here I want to do just a little bit of textual exegesis. That's a fancy word for textual interpretation or discussion of particular texts. I want to talk about legislative power, which is itself part of political power. It's a kind of political power. So let's start with that big topic of political power. I have with me in my hands John Locke's famous second treatise of government. And at the end of chapter 1, and it's a very short chapter, it's literally, 4 or 5 paragraphs. He ends chapter 1 by defining political power, because in a way the whole purpose of this little treaty, this famous treaty, remember this is the second treatise of government. There was a first treatise that Locke wrote. And in the first treatise, Locke tackled head on directly the whole notion of divine right theory of kings. The notion that some few were anointed and appointed by God to rule over the rest of us without our consent, without our permission. Really, in a way, that is what divine right theory of kings did, is it tried to justify political rule without the consent of the governed. And Locke destroys that argument. He refutes it, demolishes it. The challenge is, what do you put in place of it? That divine right theory of kings, that had been the accepted framework of thinking about political power basically for 1,500 years. If you're going to get rid of the divine right theory of kings, what is there to legitimize political power? What foundation? What principle? How can a government of any kind be said to be legitimate? If it's not God appointing a king, then what does make it legitimate? And that's the whole purpose of the second treatise. The second treatise is to make an argument about how government and political power can be legitimate. And he's going to do it ultimately with an argument of the consent of the governed. That when a government is, its purpose is just and good, that is protecting individual rights, then it can be legitimate when those individuals whose rights are going to be protected by law, by political power, when they consent to authorize, to create that government. So going into that discussion of how political power can be legitimate after refuting and demolishing the divine right theory of kings, it would make sense that Locke wants to start with a definition of political power. So it's clear what we're talking about legitimizing. And so this is the very last line of the first chapter 1 of the second treatise of government. Here's how Locke defines it. Political power I take to be a right of making laws with penalties of death. Think about that. Political power is the right to make laws with penalties of death and consequently all less penalties for the regulating and preserving of property and of employing the force of the community in the execution of such laws and in the defense of the commonwealth from foreign injury, and all this only for the public good. There's the goal, there's the nature of political power. Securing the public good, right, by protecting private property, individual liberty. And he adds, right, that political power means making laws that include the penalty of death, and therefore the laws must include all lesser penalties. Why the penalty of death? Because he's going to argue in the coming chapters that in what he calls the state of nature, every human being has the rightful authority in the state of nature to execute the law of nature. And the law of nature includes things like self-preservation, self-defense. If I'm in a state of nature and some other human being comes and attacks me and tries to harm me or take my stuff, I have the right to protect myself. And that might mean I have to kill that person. That's a rightful exercise of the executive power. And so Locke goes on after this sort of big, startling definition of political power. He will divide political power into three parts. He'll say political power consists of, and remember, it's the right to make laws with these penalties, up to and including the death penalty. So he takes that concept of political power and he divides it into three. He says there is legislative power, that is the power to make laws. There is executive power, that's the power to execute laws. And there's the judicial power, which is the power to judge when there are accusations that a law has been violated or broken. You see how all these three aspects of political power, legislative, executive, and judicial, really revolve around law. This is at the heart of this notion of political power. It's unlike any other kind of power. No other power has the power of law behind it. Political power does, government does. And all three, in a way, legislative, executive, and judicial, can be defined in light of or in relation to the idea of law, right? The power to make law, that's legislative power. Power to execute law, to enforce it, that's the executive power. And the power to judge if there's an accusation that someone has broken the laws, violated the laws. All three powers revolve around the law. That said, the American founders, very much incorporate this tripartite, this division into three, taking the political power of government and then focusing on the three aspects, legislative, executive, and judicial, to the point that they're going to create three branches of the federal government. And in those same orders, that's going to be Articles 1, 2, and 3 of the United States Constitution. Article 1 creates the legislative branch, what becomes Congress. And Article 2 defines the executive branch, the executive power, the president. And Article 3 defines the organization, the institution that will exercise judicial power, the Supreme Court. So I want to, in light of this whole discussion here of this vaccine mandate being implemented by OSHA, which is an independent regulatory agency created housed within the Department of Labor, I thought it might be a useful reminder to look at exactly how we, the people, delegate legislative power through our Constitution. If you have a copy of the Constitution with you, you might enjoy reading along. I'm going to look at the first sentence of Article 1 of the Constitution. Remember, the first sentence, of course, is the famous preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution of the United States of America. The next sentence, so this is the first sentence of Article 1, states the following. It's very short, but there's a lot packed in here. Quote, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives, period. Let me reread that for those of you who don't have the text in front of you. This is first sentence, Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, comma, which shall consist of a Senate and House of Representatives, period. There's a number of interesting features about this vesting clause of the legislative branch. Perhaps the first thing to point out is, well, the first thing to point out is it doesn't mention a Department of Labor. It doesn't mention OSHA. In fact, nowhere in the rest of the Constitution are either of those things. There is no Department of Labor mentioned. There is no occupational safety and hazard administration. Notice here in the language of the Constitution, this vesting clause, it simultaneously does two things. It grants power to a Congress. It does do that. It says all legislative powers herein granted shall be vested in a Congress, right? So it is saying there's going to be a Congress. It even tells us what Congress is. Congress consists of a Senate and a House of Representatives. And that Congress is going to have some legislative power. So it is granting, it is delegating power. We, the people, are delegating legislative power to Congress. At the same time, it limits that power. So it is both granting the power and limiting it, restricting it. It's limiting it because it's saying, yes, we the people, we are vesting legislative power in a Congress. But notice it does not say we're vesting all imaginable legislative power. It does not say members of Congress have any power they want. It does not say they have any legislative power they want. It says all legislative powers herein granted. Herein, meaning here in this Constitution, we the people are going to list legislative powers that we are giving to our Congress. What powers will Congress have? Those powers, the powers we listed, the powers herein granted, here in this Constitution. So it's really a fascinating opening statement of the Constitution, the body of the Constitution. When you think about this vesting clause of Article 1, Section 1, it's saying we the people, we're creating a Congress, a legislative body. We are granting legislative power to it, and we are limiting what that power is. We are not granting unlimited power to it. Now, when you go back and you read in Article 1, Section 8, that's the list of the powers. In fact, it begins here. I'll just read it to you. This is Article 1, Section 8. So still in Article 1, still in the legislative branch. It has what it has done. The Constitution in those early sections, it has explained, described what the House of Representatives will be, what the basic qualifications are, what the United States Senate will be, what the qualifications are to be a senator, and how you get elected. Then in Article 1, Section 8, the Constitution says the Congress shall have power to, and then there's a list, basically 17 clauses, the first being the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, and then goes on. When you read through this section of the Constitution, Article 1, Section 8, it is listing the legislative powers that Congress has. It's a very important part of the Constitution, because every time we've already talked about how all political power of government, legislative, executive, and judicial, in a way revolve around law, right? What does government do? It's either making law, creating law, or it's enforcing the law, or it's judging when there are accusations that the laws have been broken. It's all the laws are kind of the center of the universe of government. And therefore, when Congress passes a law, it's a big deal. Laws matter. Modern Americans are very persuaded that Black Lives Matter. Well, it turns out laws matter. Laws matter. And every time, because those laws are going to be enforced. They're going to be enforced. And think of that word, enforced. Every law passed, from the biggest to the most minute, is backed up by legal, lawful, potentially deadly force. And I mean every law. Every law. If you doubt this, I sometimes joke with people. I'll say, if you doubt this, that government will enforce every law with up to and including deadly force, go drive around with a broken tail light. There's a law, I guarantee, wherever you live, there's a law against driving with a broken tail light. And when the police officer is going to pull you over to tell you, give you a citation for your broken taillight, you tell that police officer you don't have time to deal with that right now. You'll get back to him in a few days, and drive off, and don't stop, and see what happens. They're going to follow you, and they're going to use all kinds of force to stop you. At some point, they might shoot you. You don't know. This point that I want to make is that laws matter. They matter because they're enforced. And if you are accused of breaking the law, violating the law, the government is going to judge you, render a judgment whether you violated the laws. And if you did violate the laws, the punishment might be terrible. You might spend the rest of your life in prison, or as Locke reminds us, the law might put you to death. There are laws that carry the death penalty. So laws matter. When Congress passes a law, therefore, the first question that should be on the minds of all citizens is the question, did we actually give Congress that right? In fact, we should ask that question before they even pass the law, right? While they're meeting and convening and they're talking about passing a law, we citizens should be asking that question. Did we give to Congress, to members of Congress, did we give them that legislative power to pass the kind of law that they're thinking about passing? And where's the answer to be found? In Article 1, Section 8. There's the list of legislative powers. We can all look at it. Every citizen can read their own Constitution, read Article 1, Section 8, and decide for themselves whether or not what Congress is proposing to do is actually constitutional. When you do that, when you open up your Constitution and you're looking at Article 1, Section 8, you'll notice several features. The first is nowhere in the Constitution, there is no legislative power at all given to the Occupational Safety and Hazard Administration. None. They have no legislative power. There is no legislative power granted to a Department of Labor. So neither of those entities, not the Department of Labor and not OSHA within it, has any power to pass a law or anything that's like law, that has the power of law. Article 1, Section 8 of the Constitution does not give Congress any power to delegate its own powers to someone or something else. No power at all. Remember what we just read, the very first sentence, all legislative power shall be vested in a Congress. The Congress is the Senate and the House of Representatives. And there's a period. It means Congress does not have any rightful authority to create some other agency and then give to that agency some of its own power. That's not constitutional. The Constitution doesn't grant that power to Congress to give away its own power. And yet Congress is creating things like the Department of Labor and OSHA within it, and it's giving to these agencies like OSHA the power to pass rules and regulations and to enforce them as if they're law. They're not law. Some of you right now might be thinking, well, come on, Cranwood, are you suggesting that all federal regulations are unconstitutional? Yes, I am. This is one of the hard things for we who care about the future of constitutional government and individual liberty and private property and the rule of law. The rule of law begins with the rule of the Constitution. In this case that I was talking about, that the Sixth Circuit, it's based, I think the Sixth Circuit is in Cincinnati, Ohio. That's where this case will be heard, whether or not the OSHA vaccine mandate is unconstitutional or somehow legally problematic. And one of the things that the lawyers who are suing the federal government, one of the things they're going to argue is that this vaccine mandate exceeds the legal authority granted to OSHA. When Congress created OSHA, Congress passed a law. And in that law, Congress said, we're creating this thing called the Occupational Safety and Hazard Administration, and here are the powers we, Congress, are giving to OSHA. And they're going to say that law does not include power to require all employers across the country who have more than 100 employees to require, individual vaccines, regardless of work environment and particular situations. And that's true. But if we say that a law passed by Congress matters, and we're going to judge the actions of OSHA according to the law that Congress passed, shouldn't we also judge Congress by the Constitution, by the standard of the Constitution? The rule of law begins with the rule of the Constitution. And the whole framework of the Constitution is to say we the people are creating this government. We are dividing the government into three branches because there are three kinds of political power: legislative, executive, and judicial. And each part of the government has precisely the powers that we the people have granted to it and no more. Those in government don't get to just exercise powers because they want to, or they think it's good, or they think it's wise. They only get to exercise the powers that we, the people, granted to them. Why? Why is this? Because of the argument John Locke made, that for a government to be legitimate, it has to be authorized by the consent of the governed. We, the people, consented to create this government through our Constitution, and we, the people, decide what powers we're going to give to those in government. They don't get to decide it. And we, the people, get to decide what legislative powers we want in our legislative branch, Congress. And we didn't give Congress any power to create a regulatory agency like OSHA. And we didn't give Congress any power to give away its own legislative power, to go create some agency and say, hey, now that we've created that agency, we're going to give away some of our legislative power to OSHA. And they can exercise it in the form of regulations. The Constitution provides for none of that at all. And it's why when you really start to think like a constitutionalist, you start to realize, well, a couple of things. Number one, you realize much of what our federal government has become is constitutionally illegitimate. It is a progressive administrative state. It is an anti-constitutional. It is a bureaucratic, administrative organization in Washington, D.C. that operates without any constitutional basis, that operates outside the boundaries of the Constitution. Some of you, some of the lawyers in our audience right now might be thinking, well, that's a question for the courts to decide. That's a question for judges to decide. And I'm here to suggest, no, it's not. It's actually not. Because what happens when Congress exercises powers it doesn't have, when Congress exercises unconstitutional powers and creates unconstitutional regulatory agencies, and then you get some jokers sitting in robes on courts upholding those things, ignoring our Constitution, and that's what the Supreme Court has been doing for 75, 85 years, routinely. Ignoring our Constitution and upholding these unconstitutional agencies and the unconstitutional regulations that they issue and the unconstitutional ways that they enforce them. So it's not ultimately up to judges and courts. You know who it's up to? It's up to us. It's up to us. What does our Constitution mean? Well, it's a question for the people who ratify it. It's a question for whom the Constitution was written. What are the very first three words of the Constitution? We the people. We the people do ordain and establish this Constitution. It's our Constitution. So more important than any judge, any court, any president, any member of Congress, more important than all of them is what we think. Is what we think. And it's time citizens start standing up and saying, you clowns in Washington, D.C., have been exercising powers we, the people, never gave to you. And it goes way beyond just this vaccine mandate. That's a tiny little example. The agency that issued it shouldn't exist. The whole department of which that agency is part, the Department of Labor, shouldn't exist. Among the many problems you get into when these agencies start to pass these regulations, we now, over the last 25 years, those federal regulatory agencies, unconstitutional regulatory agencies, have been issuing tens of thousands of pages of regulations each year. Each year. There's something called the Federal Register. That's the actual document in which all the regulations of the year are printed. And federal regulatory agencies all combined have been publishing 60, 70, 80. During the Obama administration, we got up to 90,000 pages of regulations in a year, per year. Under the administration of Donald Trump, that dropped a little bit, but it was still around 65,000 pages. I mean, 65,000 pages is better than 90,000 pages, but it's still a lot. I wanted to share with you here, since I have my clunky old copy of the Federalist Papers out. Contrary to what Charles Beard might think about it, I happen to think it's the best exposition of not just the United States Constitution, but really the political science of freedom. I want to give you one example here, talking about the legislative power that should be exercised only by Congress, not by independent regulatory agencies, only by Congress actually passing a law. Any exercise, let me put it this way, any exercise of legislative power should be done by one body, Congress, and of course, bills should be signed into law by a president, the way that the Constitution explains. But it should be Congress that writes and passes bills, writes and passes laws, not regulatory agencies. That exercise of legislative power, and it should always result in one thing: a law, an actual law, not a regulation, not a rule, a law. I'm going to read to you a short little passage. This comes from the middle of Federalist Paper number 62, which was written by James Madison. And here's what he says, quote, "It will be of little avail to the people that the laws are made by men of their own choice, if the laws be so voluminous that they cannot be read, or so incoherent that they cannot be understood. If they be repealed or revised before they are promulgated, or undergo such incessant changes that no man who knows what the law is today can guess what the law will be tomorrow. Law is defined as a rule of action, but how can that be a rule which is little known and less fixed? We don't want laws that are so voluminous. We don't want tens of thousands of pages. We don't want 60, 70, 80, 90, 100,000 pages a year of regulations pretending to be law. We want our Congress to pass few laws. Those laws that are absolutely necessary for government to do its purpose, its proper purpose, which is secure, protect the individual liberty, the natural liberty, the private property of each and every citizen. Congress should pass those laws that are necessary for that and nothing more, in which case you would have relatively few laws. And they should be short, and they should be readable, intelligible. Citizens should be able to actually read the law. The law should not be 2,500, 3,000, 4,000 pages, which has become kind of the standard in modern legislation. They should be short, they should be simple, and they should be sweet. If you want to see a model of law, go back and look at the old Northwest Ordinance of 1787. That it was first passed under the Congress of the Articles of Confederation, and that was repassed by the first Congress under the new Constitution. And it's beautiful. You can actually read it. You can understand it. And it's short and it's compact. And its goal is exactly right, which is to establish a framework of law for the protection of individual liberty and private property. That's our goal, ladies and gentlemen. That is our goal. That's our goal at the Vino Veritas Society, is to get back to being a nation of laws, which means a constitutional nation, a nation in which our government, members of our government, actually understand and know the Constitution and follow it. They don't look for excuses to exercise powers nowhere granted to them by our Constitution. And likely, what that would really look like, a government today that was genuinely constitutional, that only exercised the powers we the people gave to it, is probably unimaginable for millions of Americans. Because it would mean, first of all, huge swaths of what our government is today would go away, would be repealed, abolished, because it's unconstitutional. Probably for millions of Americans, it would probably be scary. It'd probably scare them to think that, what do you mean there might not be a Department of Labor? There might not be an OSHA enforcing vaccine mandates? There are millions of Americans today, progressive Americans, who want that kind of oversight and control. And it would scare them if those things weren't in place. And yet, with brave hearts, with courageous spirit, that's our goal, is to start to reframe, recover some semblance of a constitutional government. And that means knowing what the Constitution is. It means knowing why the Constitution is good and worth protecting and worth preserving. It means knowing what the legislative power is, as well as the executive and the judicial. And it means being able to recognize when those we delegate, those we elect to temporary offices of limited power, do things that they're not supposed to do. And that requires guardians. That requires people who are willing to guard the American idea, guard the United States Constitution. And that's what we're all about at the Vino Veritas Society. I hope my co-founder, Dave Rich, is with me next time, because he sure makes these things a lot better. Either way, we will see you next time. Nos sumos custodes.